Any mention?
May please, Your Lordship, I beg to mention item number 11.
I'm for the petitioner, my lord.
Yes. Before 2 weeks' time. No?
No objection.
At the request of this one, list after 2 weeks. Yes. Similar prayer for item number 8. Which is the other side? No one can tell me.
I'm for respondent number 1 and 2, Your Honor.
I am for 327, Your Lordship.
No, no one. You do not have objection. The request of the petition. Yes, please.
My lord, item number 19 and 20. These matters earlier on were dealt by Mr. Pinta. He has since resigned from standing counsel of the KHDC. So I've just received the files back today. So I pray that we list it after 3 weeks. I have to study it. 19 and 20. I'm on behalf of the KHDC.
Yes, Mr. State, no objection. Learned senior counsel appearing for this respondent number. You are respondent
2, 3
number
and 4. 2, 3 and 4.
2, 3, and 4. In both the matters.
Both the matters. They're connected matters.
Submits that he has received and engaged in this matter and prays for grant us some time. He has recently engaged and prays for some grant of some time to go through the matter. Prayer aloud after list after
3 weeks more.
yes, 3 weeks.
And our names may be reflected in the cause list now.
Yes, name of Mr. Tidiendo reflected in the call list as a counsel appearing for the such as yes,
Much more.
Your Lordship, I'd like to mention item number 7, Your Lordship.
item
Item 7, Your Lordship. I've taken the consent from the other side. May come after 2 weeks, Your Lordship. Yes, Your Lordship.
yes, sir. Request the request made on the petition. Not objected to by the council appearing for the state respondents. List after 2 weeks.
2 weeks. Highly
May it please, Your Lordship. Lordship, I can make a mention of item 3, Your Lordship.
Yes.
Lordship, 2 weeks may be granted, Your Lordship.
Why? Why?
Senior counsel is out of station, Your Lordship.
No objection. Sir, the request made on the respondent not objected to by the land council of the petition. This is matter after when?
After 2 weeks, Your Lordship.
Yes. Yes.
Lordship, similar prayer for item 5 and 6.
Item 5, you are the petitioner.
Lordship.
What is item 5? So many cases together?
Well, there are 4 matters actually together, my lord. Two writ petitions in item 5, my lord, and other 2 in item 6.
Your prayer is item 5 and 6. What is that 6? That is regarding what?
My lord, this is regarding forest land, my lord.
Forest land.
Forest colony, my lord.
Kindly verify whether this court had a role in this matter or not. The name looks very familiar.
My lord.
Especially this item 6. Kindly verify your government records or not.
Also, item 5 is being led by the additional advocate general, Mr. Andy Shoy from the nation stays. Number 6, I'm not.
Anyway,
My lord, I'll
it's
get
okay,
it
it's
verified.
okay, it's okay. Just even then, if you okay. Then no objection. Okay. 5 also. 5 your petitioner.
Lordship.
This will be at the request of so and so. Not objected to by so and so. This is matter after 2 weeks. And then 6 also your petitioner.
Lordship, in one of the petition, Lordship, in WPC number 152, Your Lordship, I'm the petitioner.
And 153 is also there. Okay. 153 record his name. And then the same thing. 2 weeks. Okay, no objection. Request for petition, no objection. Yes.
Item number 9. We're making a joint prayer, my lord. 2 weeks, my lord.
9. What the joint pressure made by the parties? When you want it?
After 2 weeks.
List this matter after 2 weeks. Yes.
Obliged.
May I please your lordship? My lord, yesterday my lord was pleased to allow me for one unlisted motion, my lord. And some formal defects were pointed out to by the registry, and by the time we did all the corrections, cured the defects, my lord, it was late. So my lord, may I pray again, my lord?
It will be on Monday. There is
Monday will be little.
see, it is your fault. You see, till
My lord.
evening, you even keep this
My lord.
office staffs guessing.
My
They
lord.
cannot leave.
My lord.
Court granted permission.
My lord.
You do not come and file. So
My
this creates a problem. See,
My
like
Well,
once you lose faith, then nothing remains.
my lord, I humbly apologize.
You
my
you
lord.
file it, it will come in
My
its regular course.
My lord, my lord. Obliged.
My lord, item 14, my lord, we are for the state. However, my
Yes.
lord, the counsel for the petitioner was here this morning, my lord. So he was requesting, my lord, if the matter
Item
could
14.
be, yes, my lord.
What
Because
happened?
he went out of station, my lord. Mr.
Item 14, it is informed that the learned counsel for the appellant is out of station. So, this is matter after. When shall we do it?
That come after 2 weeks. My lord.
This is matter after 2 weeks. This is a matter which was heard at some length, isn't
Yes,
it?
yes, my lord.
This is a problem, you know. Sometimes counsel pressings, and then. So, yes.
Obliged, my lord.
Please, your lordship,
Just
I'd
in
like to
view of
make,
the above, this is matter after. Yes.
I'd like to make a mention of item number 15, your lordship, if this matter may be taken after 2 weeks.
Other side? No problem.
No objection.
15. At the request made on behalf of the appellant, this is matter after 2 weeks.
Okay.
Yes.
May it please your lordship.
Yes.
Also, I beg to mention item number 18, lordship.
Yes.
Lordship, the arguing counsel is in his post, lordship. This matter can be taken up after 2 weeks.
He's occupied for the coming festival.
Lordship, I've been told he's for last.
Yes. When do you want it?
Lordship, after 2 weeks, lordship.
There is a forest matter.
No,
Or
lordship,
this
this
is
is
a bail
the juvenile justice, lordship.
Okay.
Lordship, I've already informed the other side party.
Other side is appearing in this matter.
Lordship, he is being represented by Mr. S.D. Lordship.
There is no name reflected in the cause list.
Lordship, 18, lordship, is there?
18, 1-8.
Yes, lordship, 1 day.
Yes. There is no name for the respondent. Oh, yes, yes, it's there. It's there. Yes, sorry. Yes. You inform the other side.
I've already informed, lordship.
Yes, at the request of the petitioner, list after 2 weeks.
Yes, lordship.
Yes.
Lordship, lordship.
May I please your lordship? I beg to mention item number 10. It's connected with item number 4, your lordship.
Item number 4.
Yes, lordship. 4 and 10.
4 remains in the list. 4
Yes,
is
Lord.
there in the list. It's not been mentioned, isn't it?
No, your lordship. I only have this matter after 2 weeks, your lordship.
No, it is.
4 also you are appearing.
Only in 10, your lordship.
And then 4 who is appearing.
4 I'm there, one of the
So 4 is not required to be adjourned. Only 10.
It's connected.
It's connected, your lordship.
So once one matter is adjourned, then other should be adjourned, isn't it? Okay, 10 you say the request made on behalf of so and so. You are the petitioner.
For the respondent.
Respondent, lordship.
Respondent number
2,
or
your lordship.
all the respondents.
2, your lordship.
So number 2. Then who is appearing with the other respondents?
I'm for respondent 1.
So you have no objection to the request. Oh, no one. You are the petitioner.
Yes, lordship.
You have no objection.
No.
Let's say the request made on behalf of so and so. This is matter after 2 weeks. And what is to be done in number 4? Number 4, who will make the request? And whose request shall we adjourn?
Lordship, because 10 is the main matter, because here they had challenged the
Which one? Which is the main matter?
4 is the main matter, Lordship.
Before they had challenged the 711 rejection order, Your Lordship. The 711
So Fourth
petition.
State is ready to do it.
Lordship, may I have the matter after 2 weeks, Lordship, together because they are connected, Lordship. The facts.
Hold also at the request of the petitioner.
Lordship may have it after the, if possible, Lordship, if matters can be taken up after the Easter break, Lordship.
So it will go after 3 weeks,
Lordship.
or maybe
3 weeks, Lordship.
3 weeks, Your Lordship.
3 weeks.
3 weeks.
So in both the matters, you make it 4 and 10. You make it 3 weeks. Yes.
Highly
Hello,
approach.
Lordship, I beg to mention item number 17.
Yes.
Lordship, I pay for further 3 weeks time. Lordship.
No objection, Your Lordship.
3 weeks at the request made on behalf of the. Yes.
All right.
Item number 1.
What affidavit was required to be filed, Mr.
Already is filed, my lord. Already filed, my lord.
What is that affidavit?
Service affidavit, my lord.
Service. Service upon respondent number?
My lord, it's
How many respondents are there?
6
6, my lord.
Your
respondent number 6.
name will be
6.
you'll be appearing for
Respondent number 6, my lord. I'm appearing for respondent number 6, my lord.
all the respondents.
6 only.
Only 6. And what about 1 to 5?
1 to 5, my lord, service have been effected, but my lord, they have failed to appear, my lord. It's already been served, my lord.
Where is the service report?
We have annexed to the affidavit, my lord.
They are not the contesting respondent. They are not the
my
main
lord.
parties.
They are, my lord.
What is the case about?
The main person is, my lord, respondent number 2, my lord, here. Here, my lord, basically this revision was filed against, my lord, the order passed by the trial court, wherein my lord, the trial court had refused to grant injunction, my lord. At that point of time, there was a time where civil court.
Injunction with regard to what?
Yes. We had filed, my lord, an application under section 94, my lord.
Supplementary proceedings.
Yes, my lord, supplementary proceedings. Here what happened during pendency of the, my lord, the suit, partition suit, my lord, the respondent had, my lord, carried out the, my lord, illegal constructions, and my lord had mutated patta in the name of.
So why acting CM is a party here?
My lord, here, my lord, what happened? The acting CM had partitioned the property, my lord, without calling for the NOC from the other siblings, my lord. There are daughters also who are entitled for a share in the property. Without that being called, my lord, they had partitioned the property, and on the strength of the, my lord, the patta, they've gone to the extent of, my lord, changing the names in the electricity connections, and my lord, doing other things, my lord, in the property.
No, the entire matter is pending before the trial court, my lord. This is, they have come, this matter has come because during the pendency of the matter before the trial court, and during the vacation bench, the matter has been filed, my lord. This matter actually has already been disposed of by this honorable court, my lord. White order dated, which will come at the order decision that 1712, my lord.
This by this court?
By this court, my lord. Page 39, my lord. This court has directed the parties to appear before the trial court. The trial court has fixed the matter on 3rd of Feb, my lord. In the meantime, the petitioner again had approached this honorable court by way of this civil revision, my lord. The matter before the trial court was fixed on 3rd of Feb, my lord. For appearance, SR.
What is the operative part of this order, Mr.
That will come at page.
Page 39 is order.
And
what
starts
is the
at page 39, my lord.
Yes.
Operative part, my lord, will come.
There are 4.
Page 42.
There are 4.
Paragraph 4, my lord.
The writ petition was filed by same petitioner. Yeah?
Same petitioner, my lord.
Yes.
My lord,
That-
here what had happened. My lord,
Thereafter, he did not approach the trial court.
we approach.
Yeah, then what happened?
My lord, instead of passing any orders, the trial court had issued notice and fixed the matter, my lord, post vacation.
Page
in the month of
46, my lord.
February, my lord.
Page 46, my lord.
So thereafter, we are compelled to approach this honorable court by a representation, my lord.
Now vacation
No,
is
the
over.
trial is over, my lord.
Now over, my lord. Now over,
Trial
but
court is functional.
that matter is, my
They
lord.
can agitate the entire matter, my lord. This is not for, in my respectful
See-
submission, my lord.
See, the
premature,
order
my
which you impugned,
Lordship.
but that order, the matter was fixed for 3rd February.
Third fact.
Yes, lordship.
Then what happened on 3rd February?
3rd February, my lord, the matter was not fixed. The trial court has refixed the matter, my lord.
So when it is refixed?
Now it is month of April, my lord. 15th of April, my lord.
So
Well, they can
If
agitate
I
then
may,
whatever.
if I may pray, my lord. If I may pray.
so your main grievance is that your application has not been taken up.
Yes, my lord.
That is what, let it be taken up. So what is the
Well,
problem in it?
On the date fixed, my lord, direction may be passed that the matter may be taken up on the date fixed, my lord.
When is the next date fix?
It is on. It's on 15th April, my lord.
Fifteenth.
Yes, my lord.
So we'll direct the matter will
Well,
be taken up on 15th.
Well,
No adjournment will be
yes,
done.
my lord.
But
That will suffice. Why to keep this?
yes, my lord. That can be done.
Because the application is
But,
pending before the trial court only, my lord.
If
His
Yeah.
application.
the applicable is that this miskis number 134.
Yes,
T-
my
Yes, my lord.
Yes.
But one small prayer, my lord, if my lord may consider. Here, my lord, till such time that application is disposed of, at least some kind of protection may kindly be granted, my lord.
That is yet to be considered by this court. Why? How can?
But
how
here,
can
my
you-
lord, can my lord kindly see.
Divisional court will not pass any
My
order.
lord, kindly see the first order passed by sound court, my lord.
What is the first order?
Order dated 27/12/24, my lord.
Oh, this other side has not entered appears.
Yes,
is
my
it?
lord.
Yes, my lord.
We should. Yes. What is the order?
Uh, if I may read, my lord. Para 6, my lord.
Which order?
This order dated 27/12/24, my
Where
lord.
it is?
We have not annexed, my lord, in the record of this honorable court, my lord. 27/12.
You have
The
not
first order.
annexed.
The first order passed by this honorable court, my lord. In the order sheet, my lord.
27.
Yes, my lord.
27/3.
27/12, my lord. 27/12/24.
Yes.
May I read, my lord?
Yes. Which part you want to read?
Para 6, my lord.
Yes.
In the backdrop of these facts and circumstances, the learned counsel has submitted that this court may be pleased to direct the respondents, number 2, to refrain from carrying out any construction work in the said premises till the said application pending before the trial court, being miscase number so and so, is disposed of. This court, on consideration of the submission made at the first instance, direct the petitioners to take steps for issuance of notice upon the respondents, the same renewable within 2 weeks. We have done this. Again, on consideration of submissions made as regards the ongoing constructions carried out by respondent number 2 within the suit land. In the interim, it is hereby directed no further construction work is to be carried out till disposal of miscase number so and so, my lord.
This was ex parte order, my lord, during vacation, my lord.
That is all right, but then the order remains.
Yes, my lord. Well, only thing is, my lord,
We'll wait for the appearance of the other side because just for one date and
Well,
then we'll. This will not proper. Yes, as in terms. Just a learned counsel of the petitioner submits that an affidavit showing the factum of delivery of notice upon the respondent number 125 has been filed. Stop. However, none entered appearance on behalf of the said respondents when the matter is called out. Shall we list it for hearing or?
my lord, can it for hearing only. Oh, admission hearing, my lord, because I'm challenging the maintainability also.
We just keep it to orders. We'll just
Well,
the next day we
well,
can
well,
just proceed. When shall we list it? When?
We can have it after 2 weeks, my lord.
Yes, that's prayed for.
Or, my lord, if I may pray, my lord, may kindly have this after 15th April, my lord.
After 15th April?
Yes, my lord.
You will not have any objection?
No, my lord.
That's prayed for. This is matter after 3 weeks to await appearance of the respondent number 125. Oh, yes, good pleasure.
Hearing item number 2.
Yes.
Yes, Your Honor. My lord, this is in regard to the acquisition of land without due process or the acquisition law. The petitioner has been authorized by the power of attorney to represent the Nokmas of the Garabada and Dalu village of different various Akang land, my lord. Here, my lord, in the year 2016, my lord, land was required for the purpose of construction of a road, for widening of the road, my lord. And
land was acquired.
Land was
taken. Widening the existing road.
Yes.
And by which what is the notification? By which?
No, there is no process under 84 Section 8, Act 84.
So there was no acquisition process.
There was no.
Rather than taking over land.
Taking over the.
So your land was taken over.
My land.
By whom?
By the government, PWD, for construction of road.
Yes.
So compensation has not been paid.
How much land was taken?
It is around 25 acres.
Around means which way? What is the? How many petitioners are here?
Two Nokmas, represented by the power of attorney holder. It is in paragraph 8 of page 7 of the writ petition. It is around 25.86 acres.
Then your petition names about only one petitioner.
My lord,
not two petitioners,
no,
only one petitioner.
There are another place is there next. Similar one.
Identical.
Identical.
So that case is not called now.
Not called now. It's second case. So it is total have been.
The first one is with regard to which area?
The first one is in regard to the land, the construction of road which was been.
What is the description of land which has been? Where is the description of the land in your petition?
Description is my lord. Description is not inserted in the petition description.
Then how will you conclude that?
It has been. It is lengthy.
No, that is okay. We can understand. It may be a long stretch of land.
Yes.
But then you see, like you have to say from channel what to channel what. Only something should be there.
That is mentioned.
There should be some at least identification of land.
From Garabada to Dalubaya, Ampati. It is paragraph 5.
No, that is okay. That is the road. Name of the road.
Yes.
And you are of which area?
My land falls within this.
Where did you have stated? Where you have stated? From which part to which part?
That is in the, only paragraph 5 it is been stated.
Is it a general concept? General kind of averment, saying that without a consent of Nokmas. That is all right. Then what is the land?
There is specific description. There is we don't have because it has been possessing the land from long before. So it is not yet marked.
No, then which way this court will verify what you are saying? What are the supporting materials?
In that case, my lord, I'll have a humble submission, my lord, that legislate administration may already inspected, my lord.
See,
Only land
there is
inspector.
no question of passing an order of inspection until and unless you show some primary evidence. At least you have to show some primary evidence, something. Otherwise, where is the issue? In your entire petition, there is nothing, not even a single discussion. Now come to paragraph 8, you say like, total length of the land acquired by the government of Meghalaya aforesaid Aking land is about 25 miles. Aforesaid Aking land means which Aking land?
These lands are called Aking land.
Which Aking? There Aking has different names. Now these falls which other under which Aking? If you say this is Aking land, it is a which Aking?
That is not
There is no which.
My lord, here, my lord, what happened? There was an order of this honorable court, my lord,
Yes.
to conduct an inquiry. Now, inquiry was conducted, my lord,
Okay.
by the deputy commissioner and by the revenue officer of the district council, my lord. And it was found, my lord, no land.
Where is that inquiry report?
That inquiry, that we have filed an affidavit on 23rd August 2022
By the district council.
by the district council, my lord, to bring into
Why
record.
district council is a party here, Mr.
My lord, because they are saying, my lord, that the land, because we
23/8/2022.
yes, my lord. 23/8/2022. Now, my lord, if my lord may kindly come to annexure 1.
Just a minute. Let us come to your affidavit, isn't it?
Yes, my lord. This is just to bring on record the inquiry report, my lord.
Yes. Where is the inquiry report at?
Inquiry report is on page 5, annexure 1. Now, if my lord may
Page
kindly
5.
come to, yes, page 5.
There is no page 5 in your affidavit. Oh, yes.
The
Yes,
annexure
this is a
1, my
long,
lord.
this is a long inquiry report.
Yes, it is a long inquiry report. They was present. If my lord kindly come to the internal page 4 of the report.
Yes.
Now, provided that periodic patta will not be issued in contravention to the provision of section 23 of the settlement rule frame under the Assam Land and Revenue Regulation, and no new patta shall be issued in respect of the land within one chain 66 feet of the 35 feet reservation along road maintained by the state or the union government without special order from the government. Finally, during my inquiry, it was found that few stretch of land under present improvement and upgradation of the road are patta land, and the rest of the land fall under the Nokma Aking land. In the case of PWD road, 10 meter in each side from the center of the PWD road is reserved for expansion and upgradation of such road, and accordingly to my opinion, since the expansion is within the reserved 10 meters, hence fresh acquisition of the land by the state government is not required. So what happened, my lord?
That is a inquiry by revenue officer, Garu Hills Around District.
Yes, my lord. In presence of all the parties.
Where is the order by which? Order dated 5/5/2017.
Yes, my lord.
Where is that order? Is it a part of record, Mr. Day? The order of the High Court passed in the earlier round of litigation, WPC 314.
This order dated 4/8/2022 was this.
If you see this inquiry report,
Yes,
it
my
has a reference of the order dated 5/5/2007.
Yes, my lord. But this order, my lord, if my lord may kindly see my affidavit, my lord, para 2, that this honorable court wide order dated 4/8/2022 was pleased to allow the answering respondent to file the instant additional affidavit to bring into record the inquiry report dated 15/6/2027, which was conducted by the revenue officer.
That is so far as this.
Yes,
see,
my lord.
like your affidavit is concerned.
Yes, we
But
were
then before
direct-
that.
Before that, my lord, the order was passed.
The earlier round of the order passed in the earlier round of litigation, it is not there.
No, my lord. In this matter
it was
only.
a writ petition by whom?
No. In this order, in this matter only, order was passed, my lord.
See, come to annexure 1.
Yes, my lord.
Your thing.
Yes,
See
in
the
pursuance to the
reference?
order, in pursuance to the order of the Honorable High Court Shillong, passed on 5/5/2017 in writ petition number 314 of 2016.
This is the one.
This is the one, my lord.
5/5/2017.
Yes, my lord.
This is a writ petition of 2016. We are
2016, my lord.
land acquisition matter. My lord, what for? And that too, there is nothing in this your case now disclosure.
And the Aking name is Magopada, my lord.
Okay, that is burden that has to be spelled out in the writ petition.
Yes, yes, it was not.
That is their duty to identify the land. There is
Yes,
nothing.
yes.
Now, order dated. Just a minute.
Something 5/5/2017.
See, your affidavit refers to order of. Now, if you come to first page of your affidavit, it refers to order dated 4/8/2022, isn't it? An additional affidavit filed with respect number 3 in pursuance of order dated 4/8/2022.
Yes.
And then inquiry is again in reference to some other order.
Yes, because my lord, when the inquiry was completed, my lord, then
Okay.
we was directed to file an affidavit, my lord.
5/5/2017. Just let us see what is order. See, order sheet has become much more thicker than
Thicker
the
than-
writ petition. Any affidavit filed with the petitioner against the additional.
Yes, they have filed. Now, a third person has filed this affidavit, reply to this, my lord. That is,
Third person means he is not a party to the.
he is not a party. He said that he is a power of attorney holder, whereas in the petition nothing has been mentioned, my lord. He has not.
It's mentioned in.
No, my lord. I am saying that they have not brought on record that power of attorney by which, my lord, he is claiming to be the attorney holder, my lord.
Now, Mr. Day, the order sheet reveals order sheet dated 5/5/2017.
My lord.
It's only an order of adjournment, nothing else.
No, my lord. There has to be an order, my lord. Otherwise, how we have conducted an inquiry?
3/14/2016, 3/14/2016, 5/5/2017.
Probably the date has been reflected wrongly, but there has to be an order, my lord. Otherwise, why inquiry was conducted?
There cannot be a presumption so far as when it comes to these things. There has to be a definite order.
My lord. Next. 17. Here, my lord, the order, my lord, the date was mistakenly reflected. It should have been 31st/5/2017. The order says, my lord, heard so and so, learned Deputy Commissioner, Ampati, and Revenue Officer JGC are directed to survey the land.
And just pass the order.
31st/5, my lord. It has to be.
No, the direction was to the deputy commissioner.
And the revenue officer, my lord. Because, my lord, custodian of the record is the district council, my lord.
But then land acquisition is totally subject,
No,
my lord, under the with this
district council.
no, land acquisition basically is collectors.
With the deputy commissioner, my lord. We have no role on that. Only is that, my lord, we can see that whether this land has been acquired earlier or not, my lord. Because they are record,
But
the
that
land
is all
record.
right. You see, your service can be availed for inquiry. There is no dispute to that.
Yes, yes,
Okay, and since the court has allowed you to do that,
my lord.
so there is a judicial order definitely
Yes.
that has to be. But then this inquiry is with regard to what? Are direct to survey the land in question and submit a detailed report.
The same thing which has fallen from my lord, whether what is the land which has been acquired, my lord. That was the question again, my lord, before the learned judge, my lord, at that point of time. Then, my lord, the confusion was created, my lord, that, my lord, the land was acquired, but we don't know what was the land. That is why, my lord, a survey was conducted, my lord.
See, we can understand, Mr. Day. But then that survey was for whether it was for finding out the area claimed by the petitioner, or for just taking measurement of the land, or for any other purpose, we do not know.
My lord, by reading the survey report, my lord, it appears, my lord, by reading the survey report,
the
my lord.
terms of survey has to be set by the judicial order.
Yes, yes, my lord. There is no doubt about it, my lord. But
we are not supposed to get the thing by reading the.
But it is the petitioner first who has to show the claim, my lord, that this land has been acquired.
That is, of course, you are correct there. Definitely, there is no dispute to that. Right?
Now, if the petitioner failed to do that, my lord, a judicial order was passed, but, my lord, it was not a speaking order.
But then once this inquiry goes against them,
yes, my lord,
then what this court can do?
Then now, my lord, there will be a case of, my lord, where disputed question of fact, my lord. Whereas in one hand, my lord, we are saying that there is no land which has been acquired, and that is the practical thing, my lord, which no land has been acquired.
What is the entire length of this road which is constructed, or what is the subject?
It's almost 100 kilometer, my lord.
93 kilometers.
And moreover, my lord, whether the owner who has been affected by, if in case there is any acquisition, my lord, whether they are before this honorable court.
Nakma would be rightful.
But what is the document that he has enclosed, my lord, that this is the land which has been acquired?
Mr. Day, see all those other details. Definitely, the collector can see it if there is some legitimacy in there. But then, what we are right now concerned is with the minimum. That is also is not there in the report. So that is what the problem is. Now, Are you claiming that's the entire 93-kilometer
No.
stretch?
No.
Basically, so
No,
that from which part to which part?
That is there is 25 under the 25 biggest.
No, 25 biggest from which channel to which channel?
My lord, the one inspection was done, my lord. In that inspection, we have given our reply also. Though the petitioner was present, but accurate measurement of the petitioner's land was not taken.
And then
We have given the affidavit in reply also.
what is your affidavit in reply?
We have filed a reply. Rejoinder, my lord.
When did you file a rejoinder?
Rejoinder was filed April 2017.
His affidavit was filed in 2022 and you have filed it before that. Mr. Day's affidavit bringing into record the inquiry report was filed on 23/8/2022.
My lord, in this case, there were various so many affidavits were filed by the state government.
That is all right, but then so far as his report is concerned,
This is against the state government's affidavit.
Which one? No, you said that you have filed an affidavit against the inquiry report, which Mr. Day has just referred to.
The affidavit which they have filed, my lord, in connection with the reply to the inquiry report is on 8 September 2017.
Yes.
But how it can be possible? My lord? 2017 cannot be.
That is what is. No, this there also is a wrong reference of the date. In your affidavit also, we say that this court has passed an order on 5/5/2017, directing the deputy commissioner. That is wrong. So you also get the date wrong.
No, probably they have copy paste
See
from
paragraph
mine.
3 of your rejoinder affidavit.
It's in April 17.
No, probably they have copied from my affidavit only, my lord.
No, how can? Your is came in 2022. This is filed in 2017.
Yes.
So how can the same mistake be there?
Yes, my lord.
So it seems that this objection to the inquiry was filed before the inquiry report.
Before the inquiry was conducted.
No. Before the inquiry report came into the record of this.
Yes, my lord.
Your inquiry report is dated 15/6/2017. Isn't it?
Yes, my lord.
No, they filed it thereafter.
I have filed it thereafter, my lord.
They filed it on 8 September.
Yes.
But then the thing is that if the report was brought into record by your affidavit in 2022,
Yes, my lord.
how could it means a copy of the inquiry report was there with them?
The inquiry report was there, my lord.
So
Before
why it was not annexed with this affidavit?
No, my lord. What has happened, I will point out, my lord.
this was before the Honorable Justice Sain, my lord, the matter was there at that point of time. We have placed the inquiry report. Inquiry report was taken. Then it has gone to court number 3, my lord. Then a direction was given to me, my lord, that you file this inquiry report on the basis of an affidavit to bring into record.
That is all right. This is understood.
Yes.
There is no problem with it. The question is with regard to the affidavit filed by them.
My lord.
Now, but time when they filed the affidavit objecting to your inquiry report, at that point of time there was no report available on record, isn't it?
No, inquiry report was available, my lord.
But then it was not filed on by you.
On the form of an affidavit.
No, but then it should have been a part of this affidavit then. Anyway. Then who will determine the inquiry was done properly or not done properly?
Now they have disputed, my lord. They have said, my lord, in their affidavit that inquiry was not done in a proper manner, my lord. Now there is a claim and counterclaim, and there is a dispute, my lord. If there is a claim and counterclaim, my lord, under 226, my lord, it will be very difficult to adjudicate the matter, my lord.
Yes, Mr. Nath, how do we decide inquiry was done properly or not?
My lord, that inquiry report was called for during the pendency of the writ petition.
Did you file any representation to the acquiring authority or to the land authority about the unlawful occupation or taking over your land? You filed any representation to any authorities before you approach this petition?
Yes. Representation is fine.
It is there, my lord, in the writ petition, page 16.
Representation is there, my lord.
Let us see what you have written there and to whom you have addressed it.
Deputy Commissioner.
Deputy Commissioner Revenue, inquiry dated, they have written the letter on 20th November 2015.
That is at page?
Page 16, Annexure 3, my lord.
This is filed with the attorney holder.
Yes, ma'am.
The relevant portion, the gist of the application is on page 17, my lord.
What is the state affidavit? Who is appearing for the state?
Yes, my lord, I just want to point out one thing in page 17, my lord. Now, therefore, the undersigned, on behalf of the landholder, the landowner, Nokma, would like to request you to pay fair compensation to the affected landowners, Nokmas, considering the fact that whose primary source of livelihood stand affected by the acquisition of the land for construction of the said road for Garobada to Dalu, my lord. Now, my lord, who are those people who has been affected? Nothing has been mentioned in this application also, my lord. And even in the writ petition also, my lord, who are those people who are aggrieved?
That's all right, but then
now, whether without disclosing those, my lord, can he come and file an application under 226, my lord, when he himself is not aggrieved?
See, the thing is that He is a Nokma, isn't it?
No, my lord, he is not a Nokma. He is coming on behalf of the Nokma.
Definitely, he is authorized agent of
Authorized.
Nokma.
Authorized.
He is authorized, my lord.
appointed by a duly
Yes,
executed power of attorney, isn't
yes.
it? Now, if he is representing one Nokma,
My lord.
then definitely there will be some presumption that the Nokma holds some control over the land of the Aking for which he is a Nokma.
No,
That is one thing. You see, the question of locus standi right now doesn't come, Mr. See, 2016 date petition, we are at the final stage of hearing.
no,
Yes.
that is what my lord
Well,
just
let us see
pointed
what
out.
the government says. You see,
My lord,
because
my lord.
you are not the authority who will pay.
I'm not the authority, my lord, but they have made me a party.
You can stand up to support your inquiry report, but then nothing else. It is for the state. Let us see what the state says. What is your affidavit filed with the state?
In my affidavit, my lord, para 5.
What is your reaction to this?
No, our reaction is that
This
we have not-
representation. What is your reply to that representation?
no, we have not
Representation,
acquired.
have you acted this thing? Have you received this representation?
But it is not in our record, my lord.
Where it is said it is not in your record?
No,
It's not mentioned like this.
not.
The representation was not considered. Was not taken into consideration.
How it was filed or not? How do we know it is filed or not?
We filed with we have pleaded in our writ petition.
The problem is that you see this writ petition is kept. Representation is paragraph 12. You have pleaded in your paragraph 12. For what?
Paragraph 12.
And what is the reply of the state with regard to paragraph 12?
No reply. Oh, paragraph
No,
12.
because we have not received any representation from the petitioner.
That is what you should have said.
Yes.
Have you said? Do you say that in your reply?
I will come to the para 5, my lord. It will clearly come.
Para 5
Of my affidavit, my lord.
Para 5 to 16 is replied at para 4.
Para 5, page number 4, my lord.
No, what is para 4 basically is reply to para 12. It says the statement made in para 5 to 16 of the writ petition.
Yes. Okay.
Okay. Are hereby denied.
Yes.
There may not be a specific denial, but then there is a denial. See the first line of the para 4 of the evident opposition. This is a what is the writ petition number 232 of 2016?
It is pending in the other court, my lord.
Other court?
That one.
What is the position of this matter?
232 of 2016.
Yes, my lord. Because in the record they have given that there is another petition that is 232 of 2000. At the time of filing this one, that case was pending. It was done by this Mr.
What is the outcome of that case?
I have to inquire from the KP Bhattacharjee, my lord.
But then you have referred to that case in your.
Because it is on record, so we have.
That is okay, but then now we want to see what order has been passed there. If you say a similar matter has been filed by the same petitioner raising the same plea,
yes,
then that becomes important. We have to see it.
This is for another claimant, another person.
That is what we want to see. What is that? What has been?
It's
If it concerns the same project, isn't it? Concerning the same
project.
So that is what we want to see, that order. What is that order? Was it disposed of? Has it been
No,
disposed of?
no, that as per my information that the division bench has taken the consideration that the similar matters in regard to this stretch of land is pending. So, for some information, it was been.
See, as per the roster, this writ petition number 232 should be before this court. So, but then we do not know whether it is.
The next date, my lord, the CIS is showing next date is 8/4/2025.
Oh, this case.
232. So probably it is before this honorable court only.
So that case is also pending.
Order.
These land acquisition matters are pending. The other matter. And who is the lawyer in this?
In this court, we can take together. So we'll do it. Last order.
Okay. Whether that matter is pending because of the disposal of the similar matter by the division bench. Is it the case? Then we'll do one thing. We'll have this matter also on the same day.
Yes, ma'am.
Next date is 8/4/2025.
Right.
Just wait for by the parties. This is matter on 8/4, huh? We'll not tag it with that other one. We'll just see. Just let it come up together.
Last order, the learned counsel appearing for the parties submit that the connected matter pending before the division bench, having bearing in the present matter, is yet to be disposed of. In view of the submission, this matter is pending before this bench.
Look, anyway, it will come up on it. We'll just say. This is what it is. We'll have it on 8. Your petition is neither here nor there. That is a problem, Mr. Even if court wants to give you something, some relief, even if there has to be a basis for giving relief. No details, nothing. At least you should say how much land belonging to which a king, how much you are representing, and what probable area has been acquired. If you cannot measure it, at least say this from this spot to that spot. Nothing is there. And on the top, if inquiry goes against you, then which way we can decide the correctness of inquiry? Just think about it. It's okay. All right.
Item number 12.
Yes.
This is a,
What is this matter about?
this matter is for quashing, my lord. Here, my lord, order passed under 144. 144. The allegation is, my lord, violation of the order passed under 144, my lord. From the prohibitory order, my lord. That is the allegation, my lord.
Violation of prohibitory orders.
Yes, my lord.
188 IPC or what is
Yes,
that?
my lord. 188 and my lord, 188, 186, 189, my lord. Then
Okay.
apart from this, they have also invoked other sections, my lord. So these
So matter
sections,
is charge sheeted.
my lord, charge sheeted.
It is proceeding for trial.
My lord, proceeding, my lord.
And what is the stage of the trial?
My lord, charges yet to be framed, my lord. It's pending for framing of charges, my lord.
Have you made your argument before CC? No.
Yes, my lord. We have argued, my lord, and our argument was rejected. And my lord, subsequently, what has happened, my lord? These sections 186, 88, 89, these sections were, my lord, dropped, and the London Trial Court, my lord, directed to proceed for other sections, my lord.
Okay. How long will it take?
Half an hour.
We'll come back after lunch. Yes. How many? There are some matters after this also. There are some other matters after this also. There will be.
Item number 16.
Yes.
Here just I am entering appearance on behalf of the respondent number 1 and 4.
What is? Just give me item 16.
I'll file my power today.
I think. Yes. Respondent number 1 and 4.
1 and 4.
You will enter appearance. And then?
And the rest of the respondents already appear, Your Lordship.
I'm for a district council, my lord. I'm for
Okay.
respondent 5.
So we'll record your thing. Are you ready for hearing for this matter?
No, I am entering appearance today, Lordship.
Okay. So then you'll be asking for some time.
Yes, Lordship.
Yes. Any objection in that matter?
No objection, Your
Okay,
Lordship.
just say item 16. Just say Mr. Sheikh, London Council has entered appearance on behalf of the respondent number 1 and 5. 1 and 4. 1 and 4 today. And has entered appearance and prayed for grant of some time to go through the matter. Prayer allowed. List after?
2 weeks, Your Lordship.
3 weeks, my lord. This is
3 weeks.
litigation. 3 weeks.
List after 3 weeks. Okay. The other matter we'll see in the second half.
Your Lordship.
Yes.
May I please, Lordship? Lordship, this case has arisen out of an FIR lodged, my lord, by the an officer, Mr. S.K. Sangma, my lord. Now, may I take your honor to, my lord, to the prohibitory order. On 1/6/2018, my lord, some prohibitory order was passed by the office of the Deputy District Magistrate East Kashmir, my lord. If I may kindly come to page 11. Page 11, my lord, is the original copy of the order passed under 144. Page 12, my lord, is the type copy, my lord. Yes. If my lord permit me to read. Whereas information received that there is serious breakdown of law and order, Shillong City, Motfran, Maukhar, and adjoining areas. Whereas there is every likelihood of serious breach of peace which may lead to arson, targeting vehicles, and causing loss of life and property from today and the following days. Now I therefore, I Sri P.S. Dakhar, IS District Magistrate, East Kashmir District, Shillong, in exercise of power conferred upon me under Section 144 CRPC, do hereby promulgate curfew in the following areas of Shillong City with effect from today, the 1st day of June 2018, from 4 AM till further orders. Now, my lord, this order was passed on 1/6/2018. Pursuant thereto, my lord, an FIR was lodged. If I may kindly come to page 14. Page 14 is the copy of the FIR, my lord, and page 15 is the type copy. If my lord, I may take you on, my lord, to the page 15. May I read, my lord?
Yes.
With reference to the above, I am to report that on 1/6/2018, starting from about 7:30 p.m., a group of 25 to 30 boys had gathered at Umsosun Junction above Umsosun Bridge, defying the curfew promulgated under Section 144 CRPC by the District Magistrate, using criminal force to deter police personnel from discharging lawful duty, obstructing the police personnel from enforcing the order of the District Magistrate by refusing to disperse from the area where curfew has been declared, and continuing to be present in the area by pelting stones, throwing petrol bombs, iron rods as projectile, and at the police party. The same group of boys had also set fire to a two-wheeler scooty of a non-local passerby who was going through the area, whereby the two-wheeler has been seared and completely damaged. That at about 1 AM today, 2/6/2018, during the attempt to apprehend the members of the group, the following persons were apprehended from among the group, who were rioting with weapons on the road at Umsosun, also with an attempt to enter the locality at Police Bazaar, namely Thana Road, to commit arson, harm human life, and causing damage public property. In this regard, I am to request to kindly register the FIR under appropriate section of law against the below noted persons who were apprehended from Umsosun. My lord, may kindly see, this FIR was lodged by SI SK Sangma, my lord. The order was promulgatory order, my lord. It was passed by the District Magistrate, and the FIR was lodged by the SI SK Sangma, my lord. Now, pursuant thereto, my lord, investigation was carried out, and the charge sheet was filed, my lord. My lord, the charge sheet was filed, and the case was registered as Sadar PS case number 113618 under section 143, 145, 147, 148, 186, 188, 189, 336, 353, 427, 435, and 34 IPC, my lord. Now, on completion of the investigation, charge sheet was filed under this section, my lord. Pursuant thereto, my lord, notice was issued to the petitioner herein along with other two accused. My lord, we appeared, and the matter was argued before charge, my lord. Now, I may take, my lord, to the order passed by the Lenny Trial Court, which is at page 17, my lord. But here, the London Trial Court has described my lord, the various sections under which the accused person was charged, 143, 145. So I need not read this, my lord. Now, may I take your lord to page 20, my lord. This says unlawful assembly. Let me just read this, my lord. Page 20. Since it is here, may I read from here itself, my lord. It says an assembly of five or more person is designated an unlawful assembly if the common object of the persons composing that assembly is first to overawe by criminal force or show of criminal force the central or any state government or parliament or legislature of any state or any public servant in the exercise of the lawful power of such public servant, or second to resist the execution of any law or any legal process, third to commit any mischief or criminal trespass or other offence, fourth by means of criminal force or show of criminal force to any person to take or obtain possession of any property or to deprive any person of the enjoyment of right of way or to use. This is not relevant, my lord. Here, so these are the ingredients, my lord, under which a person can be charged under section 141, my lord. Here, immediately, my lord, the allegation is that, my lord, there were 25 to 30 persons gathered, my lord, in the Umsusun area, my lord. And they say that, my lord, the other person, they fled, only 3 persons could be apprehended, my lord. That is the sum and substance, my lord. Then, when the matter was argued, now may I take my lord to the page 21. Page 21, my lord. May I just take your lordship to the first, second, third para, my lord. Therefore, while applying the definition of an unlawful assembly to the facts of the case, instant case, it is observed that there was indeed a presence of an unlawful assembly comprising of 25 to 30 boys who were violating orders passed by the district magistrate with an intention to commit various offence. This court is of the view that for an offence under section 143 to be prima facie attracted against an accused person, it is not necessary that all the members of the unlawful assembly are apprehended. The only requirement is that the person apprehended should be a member of an unlawful assembly as contained under section 142, which is present in the instant case against the accused person. The argument of the defense counsels were that the accused persons are mere daily wage laborers and passerby during the said incident and are nowhere involved with the unlawful assembly. This court is of the view that this argument cannot be adjudicated upon at this stage as the same has to be proved after cogent evidence is led by both the parties during the trial of the case. Therefore, offence under section 145 and 147 IPC is similarly attracted against the accused person, as it prima facie appears that they are members of the unlawful assembly and had refused to disperse from the area where curfew was promulgated and continued to be present there by pelting stones, throwing petrol bombs, iron rods as projectile at police party. However, this court is the view that an offence under section 148 IPC is not prima facie attracted against the accused person, as it is clear from the FIR itself and even after investigation that there was no deadly weapon seized from the possession of the accused person, my lord. Here, my lord, here what has happened? There was a gathering. There was an unlawful gathering, my lord, of 25 to 30 peoples. What happens? My accused person, my lord, he was a mere passerby, my lord, mere passerby. So what happens? What happens, my lord? There was police team. There were enough police team, my lord. There were magistrates. If there was any 144 order promulgated, my lord, there ought to have been any magistrates, my lord. There are no, there is no evidence of the magistrate that indeed there was this kind of situation. So even the magistrate was not examined, my lord.
What basis you are saying that?
My lord?
The presence of magistrate?
My lord, here here, my lord, at least
No, the requirement of presence of magistrate, where it is stated.
my lord,
Where it is.
it is, although my lord is not required, just to show, just apprise the honorable court, my lord, that if there ought to have been, if there is a law and order situation, my lord, police rightly, my
That is
lord,
the administration, they know who should be there, who should not be there. Until and unless you can show that the law requires presence of somebody,
my lord,
then where is the?
there is no, my lord, there is no strict rules that it has to be, but my situation is was as such. There ought to have, their presence ought to have been there, my lord. Why, my lord? Why I'm saying this? If something goes wrong, my lord, the first person there.
That cannot be a basis of argument in a 482.
My lord, I'm just apprising honorable court how they have reached to a finding that, my lord. I'll come to that. I'm just apprising honorable court. Thereafter, it is further observed that the act of the accused person, being members of the unlawful assembly, has prima facie caused endanger to human life and public safety. They have also used force upon the police while they were executing discharge their official duty, hence an offence punishable under section 189, 336, 353 IPC also prima facie attracted against the accused person. My lord, here, as it is admitted position, even the trial court has observed in the order that nothing has been seized. No deadly weapons has been seized. As such, 148 was, dropped, my lord. Similarly, an offence punishable under section 427, 435 prima facie against the accused persons, being the member of unlawful assembly, have caused loss and damage to public property and had burnt down their scooty. My lord, there is not even a single piece of evidence.
That will be
My
seen
lord.
at the stage of trial. See,
but prima facie, my lord,
at this stage,
yes,
you are concerned with the allegation made.
But my lord, to go ahead for the trial, at least prima facie, my lord, there has to be some kind of materials for the trial.
FIR is there.
FIR,
it is there against
yes,
you.
my lord, FIR, it says, my lord, there are not even, my lord, single evidence. Why I'm saying this, my lord, kindly see the observations made by the learned trial court. It says, my lord, nothing has been recovered. So 141, my lord. And the person,
Mr. Panthi, with this argument, what you will get.
My lord.
Just see what is the requirement.
My lord.
For getting an FIR cost under 480.
Lordship.
Just see those propositions primarily that which is known to everyone.
Lordship.
The Bhajanlal's case.
Yes, my lord.
Para 102. There are 7 stipulations. Read it. Just say, and just say what your case fits under which category. What is the prime ground here? Just say what is the ground you placed in this?
My first ground, my lord, I'm saying that, my lord, they were not part of the unlawful assembly. Why I'm saying is only 3 persons arrested, my lord. 3 persons. The prime element to constitute a crime under, my lord, unlawful activity 141, my lord. At least there should have been at least 5 persons, my lord. If they are part of the,
yes, my lord. Says there, all could not be apprehended. That is what the FIR says.
But some connection has to be there, my lord. Some connection some evidence ought to have been collected, my lord.
No, that evidence will be seen. You see, whether there was a gathering of 25-30% or not, that will be established as a trial only. It will be very difficult, you see.
My lord.
With this, I do not know. Like, probably you need some further preparation.
My lord.
Or maybe, but then what this sort of argument which you are making here,
my lord,
this could even at this stage feels that the other side is not prepared even to respond. We have not made out anything for which we should seek a reply from them.
Then in that event, my lord, my colleague grant me some time, my lord.
You can give you time, but in this kind of
I'll just prepare,
what kind of relief you can. You are named person.
Yes, my lord.
The FIR contains the allegation that there was a gathering of 25-30%.
But
they are in total.
There is no seizure from me, my lord. Nothing is there, my lord.
Seizure for that. See, seizure is not a sine qua non for the offences for which you have been.
But 141, my lord, it says that.
Maybe the court has found that 148 is not attracted.
But 141 says deadly weapon, my lord.
Because there was no seizure. So that was done very correctly. But then for other, seizure is not a sine qua non. That is why.
So subsequently, my lord, other sections were dropped, and trial court had directed my
Face
lord,
the trial, prove your innocence there.
or what I may humbly pray, my lord, if my lord may dispose of this, my lord, kindly directing the trial court to expressly dispose of the trial, my lord. That may done, my lord.
That will be there.
Why? Because till now, my lord, till now what has happened is, my lord, the matter was filed sometime in the year 2018, my lord. Charges till now has not been framed, my lord. Only with that little observation, my lord may dispose of this petition, my lord.
Okay. Status until learned counsel for the petitioner. Also Miss Anjushilla learned. What you said, you forget.
Public prosecutor, Lordship.
Only public prosecutor.
Yes, yes.
No prefix and suffix.
No, nothing, Lordship.
My prosecutor appearing along with so and so for the state respondents. For this application, the petitioner has sought for quashing of the proceeding of GRP is number 22 as of 2019. Who is pending for which court?
My lord, before the CJ, my lord.
You have not said anywhere.
I've said, my lord.
Pending before the learned Chief Judicial Magistrate Shillong. Under section 143 stroke 145, 147, 189, 336, 353, 427, 435, 34, IPC and section 6.
But 34 is not there, my lord. There is, I think, inadvertently that is. Yes, my lord. That is inadvertently reflected, my lord. My lord,
forget
page
about
21,
it. Do
my
not
lord.
mention the sanctions. Sanctions. This sections not prepared.
Page 22, my lord. It's clearly mentioned, my lord. 21, my lord. The orders.
Okay, 143, 145, 147, 189, 336, 353, 427, 435, IPC, read with RW, section 6, MMPO Act. MMPO. See at page 21, bottom of the page 21, you'll find it. Bottom of the page 21. Section 3 Act and section 3 PDPP. What is PDPP?
This is prevention of damage to public property, my lord.
This is an act.
Yes, my lord.
The word act is mentioned here. PDPP Act.
Prevention of damage to public property act.
Stop. Paragraph. After arguing at some length, the learned counsel fairly submits proceeds. The trial court by order dated 28/2023 dropped some of the charges against the petitioner and decided to proceed under the aforesaid section of under the aforesaid section of law. The petitioner would face a trial to prove his innocence, as the ground raised in this petition concerns some of the factual aspects which may become clearer if evidence is recorded in the matter. Stop. We therefore praise that the instant matter may be disposed of with the direction to the learned trial court to proceed with the trial expeditiously. To proceed and dispose of the matter. To proceed and dispose of the matter expeditiously. Give paragraph, you say learned PP. There's no objection to the prayer made. You do not have any, this is a legitimate, there is no problem with the prayer.
My lord.
So we can say that you do not have the objection with the prayer.
Lordship, I have some reservation over there because this petition was filed the year 2023 and now 2 years later to dispose of the matter expeditiously, Lordship.
Now he is saying that he will face a trial.
But trial is not in the state. Trial is not, we have not asked for the stay of the trial.
Just
trial is proceeding.
Just say the learned PP does not have any serious objection to the prayer made. However, she submits that no time frame can be fixed for disposal of a criminal trial. Paragraph. In view of the submissions, this petition stands disposed of without making any observation as to the merits of the contention raised by the petitioner. Stop. It is expected that the learned trial court would proceed with the trial without pursue the trial as expeditiously as possible. Matter stands disposed. It's neither here nor there, so you should not have any serious grievance about it.
No serious grievances, Lordship, but the thing is, Lordship, anyway, order has been passed.
Yes.
No, Lordship, because had they come up with this prayer in the year 2023, it would have been disposed of on that light, Lordship. But they wait 2 years and they want things to be expeditiously done. Something is
there was no
amiss over
stay.
here.
There was no stay, my lord.
We are not even going into that, Lordship. I'm saying, look at the period that has transpired from 23 to 25, and then they mentioned the word expeditiously, Lordship. Lordship,
do you want to say that basically the trial was obstructed because of the pendency of this case?
I'm not saying anything of that kind, Lordship, but then they should have pursued the matter if they wanted matters to be dealt with expeditiously.
You're correct, very correct. She is very correct in that thing. But then if you wanted the disposal of the trial at the earliest, then you should have pressed this petition. So that is on default. Please take note of that.
We'll take note of that.
Do not give her chance next time to raise this.
It should have been reflected then, Lordship, in the order. Anyway, Lordship.
So, otherwise also, the trial should basically
it should go on.
Proceed.
Much obliged, Lordship.